Yes, sir.
You say it's principled, but aren't there some ex parte rules binding out-of-state judges from communicating with folks to figure out what to do in their case?
Well, I think there are ex parte rules about communicating with a party. I don't know if there are ex parte rules in some forums that would preclude a judge from talking, but even that can be, like I mentioned, the ACS case. Those judges talk to each other, but they talk to each other with all the lawyers on the line, so it wasn't ex parte, and it was coordinated.
But a request for the judges to pick up the phone and sort of work it out, that's no one's privy to what's being said.
If the judges have a one-on-one communication, you're right. By definition, nobody's privy to that. And I'm not an expert on the canons of judicial ethics in all 50 states. So if there's a prohibition in some states on that, yeah, that would be a problem.
Well, let me just jump in again, because Neal, you've been sitting here very patiently, and I want to give you an opportunity to talk about how the courts have been deciding these motions of late, both the one forum motions, the motions to stay. You've taken a look at the case law here. Why don't you start off by telling us what you're seeing in terms of what's been going on out there lately?
Sure. With the focus on California, and as Professor Daines noted, there's a lot of these cases in California, and in particular in Santa Clara County. It's been very judge-specific. In the last 10 years in Santa Clara County, we've gone from the complex division being headed by Judge Komar to Judge Huber to Judge Kleinberg, and each of them have had their own approaches in terms of deference, and I think it's frankly very judge-specific. There's not a lot of appellate law in California state courts dealing with these issues, and so it's fundamentally discretionary. I was a bit surprised when I looked at the case law that California federal courts, at least in my view, have been surprisingly deferential toward proceedings in Delaware. It would have been the opposite of what I would have expected as a litigator. I think you often think about the federal judges, particularly when dealing with federal securities claims, as needing to hear those claims. Those claims are not exactly the same as what's been brought in state court by definition, because they're federal securities law claims. And I think 10 years ago, federal judges used to look at the Colorado River abstention doctrine and say, I can't only stay part of a case. I can't stay just the state law claims and then hear the securities law claims, so I'm not going to defer to anybody. I'm going to keep this whole case. And that has changed in the last few years. I think federal courts are starting to be, frankly, a bit more practical about this, trying to be fair. If there's cases that are going in Delaware that are more advanced, they're going to let them proceed. And there's a number of examples along those lines in the last 5 years, particularly Countrywide case, and most recently, November 2012, in the connection with the Amelin acquisition, a federal court judge said, I'm going to stay all proceedings here, and plaintiffs' lawyers, in connection with their fee application, should head over to Delaware.
And how about in the Delaware courts? I mean, are you seeing that from the decisions you've looked at in Delaware, are they being particularly resistant or particularly open to stay motions? Do you see a preference for one forum motions? I mean, I'll throw this open to everyone here. I don't know whether you want to start off, Neal, addressing that.
Sure. Although I will say, I think it's pretty well publicized that the Court of Chancery judges have been more outspoken about their view of the important role that Delaware plays in developing the law and in analyzing Delaware law. And I think they're frankly outspoken on that subject. There are cases that go back several years where Chancery Court has deferred to a more advanced proceeding. I think Topps was one. But I think that's grown increasingly uncommon. I did see an interesting example of one of these that involved Chancery and Santa Clara County related to Southwall Technologies. This is 2011. And Vice Chancellor Laster heard a motion to expedite discovery and to calendar a PI. And he denied it. He said, I'm not going to allow expedited discovery, and I'm not going to calendar a PI. But in the context of a one forum motion, he said, but I should keep the case. The case should go forward here, just on a slower schedule. The one forum motion was also heard in Santa Clara County, and Judge Kleinberg effectively denied the motion and said, we're going to move toward a TRO here, although he didn't allow expedited discovery either. So it was a little bit of an unusual situation. But I think it was interesting that Vice Chancellor Laster, even in a case that he didn't want to move forward quickly, he thought it should stay, frankly, in his purview.
Sure.
Yeah, and I think that case, the reason for that really that dealt with a quasi-appraisal argument that he countered. But there have been some cases in Delaware that have been stayed, and actually in the last year, I can think of 5 or 6 where other jurisdiction has been moving forward. So I don't think the Delaware court has been like stubborn that they're going to keep the case just because. I think they're actually looking at what makes sense, and sometimes it makes sense certainly to defer to what you're saying, a more advanced jurisdiction.
So, Neal, in light of what you've seen, I mean, what practical advice would you offer to defendants who are facing litigation in multiple forums about where to move to stay, when the right time is to make a one forum motion, or otherwise strategically? I mean, how do you help those of us who practice on the defense side steer our way through this maze so that we can have a case litigated just once?
Well, I certainly agree with Ken's analysis. I can think of a number of situations where I've been faced with cases in multiple jurisdictions, and seemingly not a lot has happened yet. And before a lot happens, we will reach out to the plaintiffs, and everybody knows what we're doing. We're sending either a letter or an email, which is going to be Exhibit 1 to our motion, either to stay or a one forum motion. And it's carefully worded, saying we are truly agnostic about this, but you need to work this out. It's in the court's best interest to do that. And so that's normally our preferred approach. Often the cost of doing that, in my experience, is agreeing to expedited discovery in one place or another. Plaintiffs are not that interested in coordinating if the result of the coordination is going to be you trying to shoot them down. So if you're willing to give them expedited discovery somewhere, it seems to me that in a large number of cases they can get on the same page. With respect to the cases that I think we cited, probably provided squibs on maybe 9 cases in the materials, and people can take a look at those if they'd like. Again, a large number of cases, at least in California, have resulted in stays, and I think those applications are worth making. The one thing I noticed in reading the cases in preparation for today is, on the defense side, we often spend some time briefing how burdensome this is going to be for us to have to deal with these multiple cases proceeding in multiple jurisdictions. And generally, the judges don't refer to the burden on defendants almost at all in their decisions. I think that there's a view that effectively all the parties, plaintiffs and defendants, are big girls and boys and can handle what needs to get done wherever it needs to go forward. The factor that the courts seem to spend the most time addressing is judicial resources. It's inefficient and counterproductive effectively for 2 different courts. And at a time when so many courts are so busy, it's inefficient for them to have to hear the same matter twice. So if I had to brief it tomorrow, I would be focusing first and foremost on the judicial resources point as opposed to the defense burden point.
Got it. All right, well, we've got 5 minutes left in the panel. This seems to have been a topic that's caught the interest of a fair number of our audience members. So let me first throw it off to questions from the group, and then if not, I imagine I have a few things that might be able to get these folks to talk to each other some more. But any additional questions? Yes.
I don't mean to give you a hard time. I just want to ask one question about the sophistication point. You were saying, well, gosh, I don't know what this judge outside of Delaware is going to do with respect to a termination fee. My goodness, I might actually face an injunction because I'm not going to be able to convince the court that a 3% termination fee is proper. But doesn't that speak to a larger problem of like what's going on? You know what I'm saying? Like if you can't convince a court that a termination fee of 3% shouldn't enjoin a deal, isn't that an issue? And do you really think you couldn't convince a court outside of Delaware who's like first time ever seen it that a 3% termination fee shouldn't enjoin a deal?
It depends. I mean, look, there are a lot of very good judges all over the country, and you never know. I mean, you could go into what you think is a very sophisticated jurisdiction and get a judge who's, frankly not a very good judge, and then you could go into some small county somewhere where you'd think that, you're not going to get a very good judge, and you could get somebody who's the smartest guy ever, or woman ever. So my point is that the Court of Chancery has 5 judges. They do this full-time for a living. They're very sophisticated about it. And outside of Delaware, there's a little bit of pot luck. But, you know, look, I mean, if patent cases can't be litigated in the Court of Chancery, but if they could, you probably wouldn't get very sophisticated results, because the first time you said Markman hearing to a Delaware chancellor, they'd probably look at you funny, but, you know, a federal judge would have no problem with that. So, I mean, it's just a question of what people do and what their expertise is.
Yeah, I would say at least from my perspective, we hear a lot of clients talk about sort of the concept of funny bounces in state courts nationwide, which is, again, not so much that you're going to get a bad result, but just that it can be unpredictable. We've been litigating with Randy's firm and trying to get a settlement approved in front of a very able and smart California judge who doesn't deal with these kinds of cases regularly. It's a disclosure-only settlement, and we've been hung up for several months. Most recently, his concern was, why did you issue the disclosures before you presented the settlement to the court? Shouldn't you have presented the settlement to the court, and then, if the judge signed off on it, then you issue the disclosures? And that's, I mean, there's been a few briefs submitted on that subject, good briefs submitted by Randy's firm. That's not a question I've ever heard raised before, and we've spent several months and some inefficiency just trying to get it through, and that's the kind of problem we wouldn't see, certainly in Delaware.
Further questions from the audience? Going once, going twice. All right, Juan, I'm going to give you the last word here, at least unless you don't use your full 2 minutes, and I doubt that's going to happen. You've heard what a lot of the defense counsel has said about the ways, the various methods that they use to try and wind up litigating in one forum. You've also noted your interest in seeing things proceeding forward efficiently and conserving judicial resources. What advice would you offer to defense counsel about how they should proceed in a manner that makes the cases proceed efficiently and yet only has them decided in the appropriate forum? And in responding, please do not say simply to select the forum in which you have chosen to bring the litigation.
I actually was not going to say that, but I like that answer better than what I was going to say. It's very simple. Just don't play games. We actually have seen this multi-forum, like I said, I'm not trying to beat on the defendants here today, but or defense counsel. You try to put the blame on the plaintiff bar. We're not to be blamed, at least alone. I think this is something that the defendants are also contributing to. So just don't play games, and I think stop with silly motions and really have people just coordinate efforts and tell people, coordinate efforts. And I don't know that I always see those emails as Exhibit 1. I see sometimes defendants saying, we want to be in this forum, so let's work with this group first and then try to see if the other ones will come along, and they're not coming along at an equal footing. So just don't play games, ask people to be grown-ups, and I think that's going to solve and save judicial resources and the parties' resources.
All right. Well, the time for response has been used up, so you can all take it out in the hall. We're going to take a 15-minute break now. We'll come back at 11:30 with our panel on settlements and D&O insurance. Thanks very much. See you in a few minutes.